We're good. Okay. All right. Let's take a look. All right. All right. The time is it? The time is 6:18. We'll start the Board of Zoning Appeals public workshop, public hearing, and public meeting. The first item on the agenda will be a public hearing, the continuation of a public hearing for 275 Large Street. And this is for an application proposed by the planning official and the Honorable Richard Fonte of the 6th Ward to determine whether 275 Large Street is a nuisance property.
Thanks, Louis. And just for a quick procedural thing or two, this is going to be our last in-person meeting for a while. The zoning board, we're going to go back to all Zoom, as was strongly suggested by the state legislature at their extraordinary session that occurred last week, at which a minimum of 2 and probably more members came down with COVID from being in overcrowded rooms to do their work. So we'll switch back to all Zoom after this meeting. In addition, we'll be beginning with a continuation of the public hearing on the 275 Lark Street, Cafe Hollywood. Will allow the city, Mr. Conti and the planning official to come on and rebut Hollywood's testimony from the last part of the public hearing, at which point then Hollywood, either on their own or in conjunction with their attorney, will also do a rebuttal. The board will ask questions during the 2 rebuttals. We'll also have an opportunity for public opinion from anyone who signed in for that online or in the room tonight. And if the board does come to an opinion tonight, we will only make an opinion on whether or not we find the public nuisance. There would be a separate hearing on a remedy phase. So we'll split those 2 in half. And that will only happen, as I said, if we come to a decision on whether or not the public nuisance tonight. For those of you who have not been before the zoning board before, this is a departure from my normal procedure, and this is because this is an appeal, and so we treat it differently than we do normal cases and applications that come in front of us. So I'd like to start with Mr. Conti and the city on the case of Cafe Hollywood, NC 0002. After Cafe Hollywood, we'll move on to 161 Washington Avenue Extension, which is a public workshop. And as a normal public workshop, our planning board staff will present the case, the board will ask questions, and we'll ask staff to reach out to the applicants and provide us with more evidence to supplement the record for a future public hearing. And then at the end of that, we have a public meeting agenda where we will discuss some cases we've already heard in public hearing from the board. So, Mr. Conti, if you'd like to start off with your rebuttal to Cafe Hollywood.
I believe Mr. Glass.
Yeah, we have 2 participants who are participating virtually, Louise. Sorry, Richard and Richard. So Brad Glass, who's one of the complainants, and then the respondent, Colin Rose. He's represented here by his attorney in person, Mr. Hannigan, but I believe Colin Rose is virtual right now.
Colin Rose, you can unmute and have the ability to speak.
And also Brad.
It's already panelist.
And is Mr. Glass also on?
Yes.
Can you hear me?
Yes, and I believe Brad was going to lead off.
Hi, this is Brad. Can everyone hear me?
Yes, Brad.
Okay, just wanted to let you all know too that the video is not currently streaming for whatever reason. It was on and then it went off. Would you like me to start?
Hold on 1 second, Brad. You should see the PowerPoint right now. I'm screen sharing that. Do you not see that, Brad?
Yeah, I can see the PowerPoint. I just don't see the live view of the room anymore.
Oh, right.
Which is okay. I'm going to present remotely without video, so I don't mind. I just wanted to let you know. There you go.
Okay, Brad, go ahead.
Thank you, everyone, and I apologize for being remote again. I am off this week, but I did want to take time for this because I think it's important. Just speaking again to the main body of evidence here, which is the Albany Police Department record of 120 services calls between November 2019 and July 2021 to 275 Lark Street, otherwise known as Cafe Hollywood. Among these calls includes documentation of a physical attack upon another person with a machete, as well as a gunshot death. But calls also relate to generally violent and disruptive behavior, noise complaints, fireworks, reports of drunkenness, as well as injuries. These incidents show there's a documented pattern of disruptive behavior culminating at 275 Lark Street, which has in turn negatively affected the safety, livability, and welfare of nearby neighbors, both business and residential, that supports the BZA's authority to declare a nuisance. Now, we did consider these calls in the light of other nearby establishments, similar and dissimilar. The record of calls to APD for the other establishments in the case of bars or taverns do not exceed even half. In case the closest comparable was 51 APD service calls during the same period as compared to 120. There are establishments such as Price Chopper in particular. In fact, Price Chopper is the only establishment in the immediate area that exceeds the number of calls that Cafe Hollywood had with 331 service calls. I will point out that Price Chopper, unlike Cafe Hollywood, does provide an essential service to the neighborhood, and I think that should be taken in consideration. And those calls, as a ratio and proportion, do not project the same level of violence that's occurring related to the property at 275 Lark Street. So that was some information that the respondents asked for that we provided. We believe further supports our case. We also wanted to note that there have been zero 911 calls associated with Cafe Hollywood in the past month or so. That's documenting the fact that it has been closed and that call volume has dissipated significantly. I believe the respondent had alleged that some of the calls may have been inadvertently going to their establishment, or it was used as a particular incident location that's being used with respect to incidents that aren't occurring there. That does not appear to be the case based upon and in light of this evidence. I also just wanted to project a general picture here of the 35 or so years that this establishment or similar establishments have operated at the location. This business is operating under a use permit essentially for the, I believe it was called the Beverwick Cafe, that was established in the mid to late 1980s. Since then, it has evolved significantly to the use that we've spoken to in the context of this case today. In that time, there has been no real transparency as to that change occurring. There's been no hearing before this board. There's been no notification of other neighbor establishments, business improvement district, that sort. So that the changes that are being proposed here or that have occurred here could be discussed, and some of the problems that have occurred could potentially have been prevented. So I did just want to put out that history. I also did want to point out that in the context of this review, we've also discovered that Cafe Hollywood was operating without a valid cabaret license from the city. So any live entertainment that's been occurring there has been without the consent and review of the city under those procedures. Cafe Hollywood also did not have a valid cafe permit for the cafe in front of their business. And as been part of the conversation here, we know that that's been a point of contention as to some of the issues stemming in that location with respect to the calls that have been documented. And, you know, as far as we're concerned, there's been no valid permit applied for, issued for that cafe or for the ability for the establishment to have live music or entertainment. I believe Mr. Conti was going to speak further on this matter, so I will defer to Mr. Conti and happy to answer any questions.
Thank you, Brad. Members of the board, I just want to make a couple of other points. First, I want to remind members that Chief Hawkins has already made a determination under the separate nuisance abatement law that the property business constitutes a nuisance. The findings that he's required to make under that law are very specific. The law is very specific in terms of guidelines and types of incidents. So that's a very strict standard. This board is held to a much more general standard. So you might argue that if you want to use it under the very specific nuisance abatement law, that suggests that this board might should consider that as well. I also wanted just to note a couple of issues because we talk sometimes about the operation of the establishment, and from what we understand, they have put in place security measures that include metal detectors, frisking and patting down on their patrons as they enter, a high security guard to patron ratio, and number of security cameras. Even so, I mean, this seems to indicate that the business model itself creates an issue that lends itself to incidents that occur within the establishment and are then moved outside where they might occur. That's the case with the shed incident that you heard about, as well as the homicide, gunfight, gunshot, which resulted in the homicide on July 23rd, which is the incident that really precipitated this action. So it is basically operating essentially as a nightclub without a cabaret license, as Mr. Glass noted, in a mixed-use neighborhood with very densely populated residential, surrounded by very densely populated residential area. And so the use itself really lends itself to being used. I also wanted to discuss a letter earlier today from the president of the Hudson Park Neighborhood Association, who was just making some observations in terms of the difference between what the neighborhood was experiencing, how it was operating, and what they're experiencing right now. Not to read the whole letter, but just to summarize a couple of points, states that since the closure, our residents report the following: noticeable decline in reporting noise and nuisance-related issues. Multiple residents have remarked concerning the positive change. Less aggressive behavior by drivers between the 10 p.m. and 2 a.m. hours on both Large Street and Hamilton Street, which is used as an exit point from the neighborhood via the Empire State West Loop. And less destruction of physical properties such as urinating on and underused, vomiting underused, and tree beds, transport of planters and tree beds, and less broken bottles and takeout trash left on the curb in the street. So there are certain impacts that really kind of less. So otherwise, reiterating the points that we made in our complaint, be happy to answer any questions you might have later.
Thank you. Are there, Richard, if you could stay up at the podium, and are there any questions from the board?
Mr. Chairman, I could, a couple questions for Brad Glass. Brad, you talked about use expanding at the premises. Could you go into some detail as to what the city has defined as an expanded use, or what sorts of triggers would have been necessary for them to go before the planning board or board of zoning appeal that were not done?
Well, I think overall it paints a picture of a demonstrable change in the intensiveness of the use. Very unclear where that leaves us. Again, it's been over a considerable period of time. The original zoning that was in place for this was commercial mall. It's a designation that doesn't exist anymore. That was when the Beverwick was established. I wasn't around back then. I have been with the city for some time, but can't speak to the actual conditions, but my understanding was that was a casual or fine dining type of establishment. The current business, has been described as a nightclub. It's been described as a bar. I don't think anyone's described it as a restaurant. So I think just in terms of terminology, there's a difference there. Our zoning definitions have changed numerous times over that course, so it can be difficult to track. But frankly, the business is operating under grandfathered hours that were in place at the time when the Beverwick restaurant was established. And again, this was upwards of 30 years ago. So that, coupled with how the use has changed to essentially host large gatherings that are requiring a security presence, as well as entertainment and other sort of impacts. Again, that wasn't what was, I think, initially described to the authorities at that time. And that, there's been a change over time that at some point, I think that does come under purview of this board, regardless of any nuisance establishment that's at play, but it's certainly relevant to this case as well. Does that answer your question?
Yeah, for now, thank you.
Are there any further questions from the board for Mr. Glass and Mr. Dante?
Brad, could you talk a little bit about the cafe being used at the front of the establishment? You said that there was no permit for the operation of the cafe at the front of the establishment?
That's right. There may have been a permit at one time, but that has lapsed. And that, coupled with the lack of a cabaret license, again, just speaks to the general fact of, concerns about management and some of the other concerns that have been expressed in the context of this application. And particularly with respect to any live entertainment that's occurring, again, that has not been sanctioned by the city. So to the extent that any of the incidents stemmed from that, we would argue that these further relate to the proceedings at hand.
Thanks, Brad. Are there any further questions from the board?
Councilman, can you just speak to what we spoke about a little bit with other similar establishments in the neighborhood also having reports to the APD? In your experience, in your opinion, is there a marked difference between what you've seen and heard at Cafe Hollywood compared to neighboring?
Yeah, I think when you look at calls for service, you can look at the numbers, but you really then need to dig into the details as to what that call was, the police response, and which is information that we provided to you. And you'll see a marked difference between the reason, I think, for the calls at Hollywood versus other establishments. Luxury is a lively district with a lot of establishments that are open up later. You will get complaints, sometimes about noise, sometimes about crowd. They don't raise to the same level of incidents that result in a fight or violence, things of that nature. So I think that's the main difference. In any commercial, especially mixed-use area, you're going to see calls about different establishments. The calls here are different in that they relate more to incidents that, with violent acts, fights, things of that nature.
Thank you.
Are there any further questions from the board?
Yeah, for a follow-up to Brad, we don't define a nightclub in the USDO. So when you talk about live music, entertainment, amplified music, I'm assuming you're referring to it as the way we define it as a cabaret. Are you aware of any other establishments on the luxury area that have failed to submit a cabaret license or have had theirs revoked because of complaints about music or activities at those establishments?
Martin, I don't have that information readily available.
I have a question for the council member. Thanks, Brad. The Sidewalk Cafe permits, do they expire every year? And if they do, does the owner have to come in and ask for a new one?
Since they're now referred to by the planning department as a revocable permit, I believe that, and Brad can correct me, that, they continue until, but they have to be, there's a fee paid every year. But Brad is the one who administers that process, so he can answer it more.
So thank you, and Brad, to follow up on that question that I asked Mr. Conti, is there any kind of difficulty that an establishment would have for getting the Sidewalk cafe permit?
No, it's a relatively straightforward process. If a permit has been approved previously, the establishments are notified on an annual basis that they need to essentially notify us of any changes and to provide an insurance certificate that holds the city harmless as to anything that may occur with respect to that area. So there's somewhat of an important element documenting that. I believe there was a comment that an application was filed for this year. That application was filed only upon a notice being issued that a valid revocable street privilege was not in place with respect to the front cafe. So that application came subsequent to that notice of violation.
Thank you, and moving on to the Cabaret license, is there a process that an establishment has to go through on an annual or some other periodic basis to obtain and renew a Cabaret license?
Yes, that process is through the city clerk's office, and we did reach and confirm that there was not a valid license. For any additional information on that procedure, I'd have to defer to those individuals in the clerk's office that administer that, or perhaps our attorneys can speak to that.
Yeah, so the procedure is that for an initial Cabaret license, there is a public hearing with notice to property owners within a certain radius, I think 200 feet radius. For the first time, then subsequent, there are renewals, and that renewal application is circulated amongst to various departments, including the council member, before the city clerk actually acts. So, checking in the city clerk's office, there's no record of a current Cabaret license at that address.
Councilman, do you know how often those renewals have to be filed for the Cabaret license?
Yeah, it's an annual license.
Thank you, and this is for either Brad or for you, Mr. Conti. Is it your contention that the 120 service calls that were made to the APD are evidence of the premises being a hazard to the health, safety, or welfare of the neighborhood?
Yes. It's not simply the number, again, to repeat it, it's not simply the number. We have to then look at the actual detail. That's, I think, what you look at, and that's would make our case that there's a threat to health, safety, and welfare.
Thank you, and the language in the USDO provides also for essentially a consideration of the general nuisance, and I was curious to see if you asserted that the operation without the proper Cabaret license and sidewalk permit essentially was a nuisance to the neighborhood.
I think part of the case that constitutes, but there's also the incidents that occurred. And operating as, in effect as a nightclub could be a draw that in effect then creates the environment, the venue that results in the incidents that then break out and occur outside.
Thank you. Are there any further questions from the board for Mr. Conti and Mr. Glass at this point? Okay, thank you both, and we'll hear a rebuttal from Mr. Glass, counsel.
Good evening, Honorable Board. My name is Trevor Hannigan. I'm here on behalf of Cafe Hollywood.
Please proceed.
Thank you. I submit that on August 11th, the board had recommended that I foil certain records to be provided to my office so that I could demonstrate comparison with respect to the allegations in the complaint that is pending before this honorable board. with respect to my client. As I acknowledged to the board, I had done so on August 10th, 2021, and anticipated that I would have those records prior to our adjourned hearing. Unfortunately, I do not have those records. I received an email from the city today indicating that my FOIL request under FOIL number W015371-081021 is going to require an additional 20 days to supply me or furnish me with that information. I submit that prior to this board taking any action to determine whether a nuisance exists at 275 Lark Street, my client should have an opportunity to present these records. As Mr. Glass and Mr. Conti have discussed with this board, they presented evidence that I simply cannot rebut, particularly with respect to the cost for service at the other establishments that I have suggested that we review in order to give a fair shake to Cafe Hollywood. I cannot confirm or deny that 331 calls were made to Price Chopper, or 51 other service calls versus the 120 service calls that were alleged against our location is somehow different. I agree with Mr. Conti. The devil's in the details, ladies and gentlemen. The details with respect to the nuisance claim. I submit that a pound for pound or a comparison of apples to apples should be addressed. Certainly there are calls for service at 275 Lark Street. We do not deny that. We've acknowledged that, we have owned that. We dispute that every one of those calls for service are directly related to our establishment. I further submit that the calls for service, even the most egregious, I submit, the two that seem to rest on the most violence, the one from the machete incident in June and the one from the homicide on Willett Street in July, are not necessarily directly related to Cafe Hollywood because they did not occur inside of the establishment, nor did they occur on the curtilage, I submit, which is the sidewalks, the driveway, the rear parking lot, or even in the middle of the street in front of the establishment. I submit that the machete attack happened after there was a fight inside of the bar. I submit that the patrons who engaged in this activity were escorted out by my client's security personnel, and that an hour later, at least an hour later after the victim of the fight inside left the establishment, I submit that the perpetrator of the machete attack was lying in wait, waiting for the other person to leave. So Cafe Hollywood has attempted to address and ameliorate the issues that this board and the individuals who filed the complaint seek to address. The homicide, while an unfortunate event that resulted in the death of a young person, certainly happened a few blocks away, and I submit that my clients didn't have a hand in the assassination of this other individual. The perpetrators, the people who killed this young man, are to blame. Certainly we acknowledge that the individual who was murdered was a patron of our establishment, but there is in no way a link, casually or otherwise, to Cafe Hollywood, because if there had been, I further submit that the state liquor authority would have taken immediate and corrective action and sought to enjoin my clients from selling alcohol, which has not happened. I further submit, ladies and gentlemen, that the calls for service with respect to noise complaints, with respect to parking issues, certainly can be addressed without the revocation of my client's special use permit should this board find that those create a nuisance for the immediate area and neighborhood of Center Square. We have to address the security measures that have been put into place by Cafe Hollywood as recently as February 2020 after they hired new security staff. Certainly there was little or no calls during the pandemic after they would be permitted to open. And I submit that in order to have a fair opportunity to rebut the claims that have been made here on rebuttal, this board should permit an adjournment of my rebuttal, and certainly I would consent to assert rebuttal by Mr. Glass or Mr. Conti once I've had an opportunity to review the information that they've referenced in their rebuttal. I have not been provided with the information that I submit would be relevant to demonstrate whether the calls are similar or dissimilar to what is transpiring as it relates to 275 Wall Street. I would cede any remaining time that I have to questions of the board.
Thank you, Council. Do you have any questions from the board?
Sure, I guess, thank you for your testimony. I wanted to ask you, you mentioned that your client had made several investments in upping their security, including cameras, wanding, and metal detector, maybe the same as wanding. Does your client have records as far as employment on weekends or nights that were problematic that would demonstrate their investment in ensuring safety at their facilities, such as how many bouncers were on staff or those sets of employment records to demonstrate that?
Yes, my client employs an outside security agency that's fully licensed, and who requires licenses of their security personnel. My understanding pursuant to my discussions with this particular company is that security starts at 8 p.m. on the evenings that are typically problematic, right? Thursdays, Fridays, and Saturdays. They start with a smaller security staff. These records certainly would buttress my statements to this board. However, my understanding is, and I can't speak to specific numbers and specific times, but at 8 o'clock when the security starts, that includes all of the wanding, coming in, checking identifications to make sure the persons are of legal age, allowing the patrons into the establishment. More security staff comes on. They have a ratio somewhere between 20 patrons, 22 patrons to one security agent, where they had been during the time of operation, during those high volume, potentially problematic time periods when bars and restaurants typically have an increase in patrons and increase of patrons who are drinking more. But should that be something that the board would like to see, I would respectfully.
Sorry.
No, please.
I believe it was the prior hearing that we had where it may have been the applicant or manager stated they had as many as 10 to 15 security staff at the restaurant.
As the night would go on, I'm sorry to interrupt.
At Hollywood on any given night.
As the night that would go on, that would be my understanding. They start with a few, and then as the hours get later, more security personnel is added to different areas of the establishment. They have the front door immediately attended to by security, and as the night goes on, they would have more people in the immediate bar well area. They have more towards the back. They would have more towards the rear area where they have an outdoor patio. So depending on the time of night, there would be more security personnel.
In my experience going out, which isn't as late as it used to be, normally going to a restaurant or a bar to enjoy music or watch a sporting event or see friends, I'm not used to seeing that level of security at most establishments. Is there something unique about this business which requires the use of 10 to 15 security guards that's not the case at any other establishment in the district?
Well, I submit that that would be my client seeking to prevent any issues inside of his establishment and trying to protect the general neighborhood around his establishment. I further submit just because other establishments don't necessarily employ this level of security doesn't and shouldn't mean that my client is doing something wrong. I submit that my client is attempting to make his patrons feel safe by inviting people in only after they've been screened for security. Well, your experience may be different from another person's experience. I submit it depends also on the types of people who are coming out at different times. And if people feel secure because they're being protected by the security personnel inside of the establishment, that only goes hand in hand with respect to the noise complaints. And I submit to the traffic. People are happy to come here because they know that if they go inside, they're gonna be safe.
Thanks for sharing.
Are there any questions from the board?
Could you speak a little bit more about the point you made about the fact that the state liquor authority did not revoke Cafe Hollywood's liquor license as being evidence of the lack of culpability or responsibility by Cafe Hollywood?
Certainly. We acknowledge that the chief of the Albany Police Department has established an emergency order that shut down Cafe Hollywood. I submit that, don't be fooled. This board can make a separate and independent determination. Do not rely on the chief's order to make a decision in this instance. There's a different standard, certainly I acknowledge, as Mr. Conti has submitted, but just because one went one way, I submit that there's a whole bunch of other legal issues that I won't bore this board with. But to speak to your point, the state liquor authority, in each of our common collective experiences, right? You know, if you go out, there's a problem at a bar, the SLA shuts it down. Think about during the pandemic. I'm not going to speak to any particular establishments in the capital district, but we know there were certain establishments that were cited throughout the pandemic for having too many patrons, for having patrons not wearing masks, for bars not complying with the governor's executive order as it related to the pandemic. They were quick, I submit, the SLA, I mean, were quick to jump on those establishments that weren't abiding by Governor Cuomo's executive order to make sure people were being masked and there were certain distances between patrons. They would be even faster, I further submit, if they thought that a bar had a hand in a homicide. And to date, there has been no SLA action taken.
Thank you, Council. I'd like to follow up on that because I find it an interesting argument. So the governor's executive orders changed a great deal of the law of New York State. His executive orders regarding the behavior of restaurants and other indoor establishments changed the basic law and regulations with respect to those operations. Are you asserting that there is something in the state liquor law or in the regulations of the SLA that requires them to revoke a liquor license on a report of violence at a bar?
The state liquor authority enjoys broad discretion as it relates to its licensees with respect to the revocation, suspension, and anything else that they'd like to do. I submit that if a board thinks that there are underage patrons, people are not complying with the law, or engaging in violent and tumultuous behavior which would endanger the safety in the community that the license is granted to, I submit that the SLA would take it away. I mean, they're taking away people's licenses because they're not wearing a mask. I submit that if they believe that there was a homicide directly related to conduct by an establishment that's issued a liquor and a beer or wine or any sort of permit by the SLA, they would stop that. They would not allow that to continue.
So just to ask this question slightly differently, the first two examples that you gave, which was underage and overcrowded over the legal occupation limit, those are part of the regulations in the state liquor law. Is there anything in the state liquor law or the SLA regulations that would require the board to act on a report of violence at a bar?
If there is tumultuous behavior, I submit, the state liquor authority retains the power to suspend or revoke the licensee's license until such time as they can make a determination as to what the bar's culpability is in that regard.
Thank you. To follow up on that a little bit more, are you suggesting that the SLA was aware of the murder and of the machete attack at the bar?
I can't speak to what the SLA is aware of.
Okay, thank you. You made a statement that the violence didn't happen inside, in back of, or on the curtilage of the property, or I guess for the purposes of the non-lawyers in the audience, on or near the property line. What distance would you suggest is where Mr. Ross's liability for the behavior of his patrons, that he served alcohol and may or may not have tolerated behavior in the bar? Where does that come up? What distance?
That's a good question. I don't know if I can give you a distance. It's not like a stay away or 500 feet, right? I think that the bar is responsible for acts that happen inside of the bar, certainly we will agree. Immediately outside of the bar, I think that we can agree. But if something happens an hour later, even if it's in the general vicinity of the bar, how could my client anticipate what is in the mind of another individual? I agree with you. If it's something temporal, it's related in time and scope, we'll take the hit. There's no question about it. But somebody who's in the establishment, walking home several blocks away, how can we, without assuring that individual to have some sort of escort, either from the bar security itself or another private security firm, or the Albany Police Department, we don't know what's gonna happen. And certainly if any patron of the establishment had requested a security escort, my client wouldn't refuse that. My client would walk anybody out or wait with someone to have an Uber there, or as has been described to me by my client and his staff, take them home themselves.
Thank you, counsel. So you also commented that in the case, I think it was of the machete attack, and forgive me if I get these two wrong, that the two people involved in that had been fighting inside the bar, were separated by Mr. Ross employees, and then were ushered out the door. Since he had knowledge that they were fighting, are you still suggesting that even when they walked away, when he knew that they had been engaged in violence inside his establishment, that he had no requirement to do anything when they walked out the door?
Well, do anything, I don't necessarily agree with that. No, I think that he has, my client has a responsibility to his patrons and to the city. I mean, we live here, right? To ensure that violence doesn't happen. We don't want to see anybody get hurt. Patrons are business, right? We don't want anybody to get hurt. But to diffuse a situation inside by security, my understanding after discussing the security detail with the security corporation itself is that the situation is separated by separate security agents, and one person is escorted out first. There's a period of time that is waited or elapses before another individual is then escorted out. So they get sent separately at separate times on their way. Certainly, once they have been ejected from the establishment and a period of time has gone by, I submit that absent my clients contacting the police that there had been perhaps an incident inside of the bar, I don't understand how an incident that happens almost an hour later, my clients could be held responsible for that.
I think you actually brought up my next question, which is, did Mr. Ross or any of his employees call the Albany Police Department and tell them that there had been violence inside the bar and they had been escorted out, whether or not at different times, but that the people engaged in the altercation had been put outside into the streets, and that, you know, whatever happens next, the cops should know about it?
I can't speak for the entire security detail. I don't believe that the Albany Police Department was contacted on that particular occasion. But certainly, and I didn't review it in the calls for service that were provided to me by Corporation Counsel.
Okay, thank you. To go back to your idea of the temporal connection between something occurring inside the bar, or being inside the bar and being a customer, and then something happens subsequently, would you agree that a bar owner has liability if someone has a amount of alcohol sufficient to go over a legal limit, either for driving while impaired or a DWI, drives later and then gets in an accident?
I'm familiar with the Dram Shop Act.
Yes, that's where I was leading, yeah.
I'm not, my personal feelings regarding the Dram Shop Act is regardless. That's the law of the state of New York. As an attorney licensed pursuant to the conditions of the state of New York, that's what it is. My client has liability if he overserves somebody and somebody got forbid gets hurt.
Is there any temporal disconnect? So if they are served or somehow manage to get alcohol above the legal limit, go out and get in an accident, whether or not someone dies, is there some kind of a time period where he loses his liability for letting them go out like that?
Certainly. I mean, who knows? Maybe there could be superseding intervening facts that would mitigate, that would lessen the culpability, the liability to my client. If a person leaves and they wait an hour or two, that may be a significant mitigating factor. If the person leaves and goes to another establishment, if the person goes outside and smokes marijuana and has more to drink at the corner bodega, these are all superseding intervening facts that my client couldn't control.
Are you aware of any additional facts that may supersede whatever liability Mr. Ross might have had for serving them in his establishment subsequently, such as the list that you just gave?
The Albany Police Department hasn't favored me with a copy of the investigative notes with respect to those particular incidents.
Thank you, good answer. Okay, and then I guess the next question is still sticking with the same alcohol and driving hypothetical, because it's one that we're all, as upstairs, where bars tend to be long distances from our houses. I think most of the people in the room, unfortunately, have driven with a drink or two at one time in their life. Would it make any difference from the in this hypothetical, if two people got out, got in their cars and had an accident in front of the bar as opposed to down the block or in another town, wouldn't there still be liability for Mr. Ross if they were overserved?
Depends on if they were the entity that overserved them, and it depends on what the nature of the accident was. If it was attributable to an alcohol distraction, or if it was attributable to other sources, perhaps not.
Thank you. I want to go back to the issue of the security force for a moment. Mr. Ross testified to the board, as I think also his manager did, although not certain about her. But he said that it was the largest security force of any establishment in the Lark Street corridor that he was aware of. Is that true?
I believe my client believes that his security detail is the largest. I'm sure as a business owner on Lark Street and as a member of the Lark Street Improvement, the BID, right, the Better Improvement District, there is some sort of friendliness that goes on amongst the different owners of the different establishments. I'm sure he walks in and sees.
Thank you. And I think you said that they moved to the new security size in, February. And what year was that, February?
My understanding was that was February 2020, late January, February 2020.
And how big was the security force before they moved to the larger security force in February?
I think they had, I can't speak to the specific number. I know that it was an unprofessional, uncertified force.
Was it smaller or larger?
I think that that question can't be answered because it's based upon a day. What day would you be asking about as opposed to what day? We need to compare the days.
Are you able to speak to why Mr. Ross might have felt it was necessary, given that all business establishments need to make money and things like additional security cost money? Could you speak to why he felt it was necessary to increase the size of the security force?
I think that that was reactive to an incident that was alleged and occurred in late November 2019, where one of his staff was injured.
Okay, thank you. Do you have any further questions from the board? One second, Council.
Can you speak to the point that the other side made about Cafe Hollywood operating without the cafe license and the cabaret license?
My understanding is that with respect to the cafe, the Sidewalk cafe permit, my client had continued to enjoy a cafe permit up until 2019. I think that they applied for a permit. I do agree that it is an annual application. I don't think anything had changed, except during the pandemic, everything was shut down. I do believe they applied. I can't state when they applied in 2021. It may have been as a result of an allegation, but that could have been perhaps a mere oversight on my client's part as well, because it had been a long-standing sidewalk permit. With respect to the Cabernet licensing, I can't speak to that. I don't know of any dates that an application was made, but I also am unaware of any. I mean, cabaret is certainly something that is pursuant to the code, defined very broadly. It could even be dancing. It doesn't necessarily have to just be live music. If you read the code, it could be people dancing in your establishment. So if you and I wanted to dance to a song, I think that my client would be in violation of the cabaret license. Cabaret permit.
Thank you. That may be more accurate for New York City, where they obviously dance more than we do. But appreciate it, Council. At this point, if we don't have any further questions from the board. Oh,
I do. And just walk me through it, and if you need to follow up, that's fine. You had mentioned the security force is an outside entity and their license.
Yes.
So when I think of a bouncer, I'm just thinking of a big dude at a door.
Fair enough.
But there's a difference between a big dude at a door and a person who is licensed and trained.
Yes.
Can you help me out just to understand the difference?
The training and the licensing?
Well, what the licensing and the training, as opposed to like the guy who played football, who I'm scared of.
So my understanding is the big dude at the door who you might be intimidated by because he's double your size and strong, may not necessarily know how to diffuse the situation inside of the establishment. May just be able to use his or her brute strength and size to merely intimidate you or me or anyone else into doing what he or she wants you to do. A security force, I submit, that's trained is trained to de-escalate problems inside of the bar, perhaps even before they arise. So if they say you and I are standing next to each other and I bump you at the bar and I maybe spill a drink on you, perhaps the security intervenes and says, okay guys, hey look, there's no problem, we're gonna buy you a drink. We're gonna make sure this all goes away. It's the level of education that would protect the scuffles from becoming major things, and perhaps major things that could not be prevented immediately from becoming terrible things that happen inside of the establishment.
Thanks.
Thank you, Council.
Revisiting the Cabaret and Sidewalk cafe licenses, you mentioned, I believe, with the cafe license that it expired in 2019, and there may have been an oversight on Mr. Bruce's part for applying for the new one. Do you know, had he applied for either license in 2021 after it had lapsed?
I believe, I cannot speak to the Cabaret license. I don't think there was ever an application for a Cabaret license, but I could be mistaken. With respect to the sidewalk permit, I believe that when it was brought to his attention with respect to something being outside, and they didn't have, when I mean something with chairs, tables, and they didn't have a necessary permit, I think that that was the moment that the oversight was one of those moments. Maybe we need to make this application now because we didn't deal with it.
Thank you. And you had mentioned that, and we spoke about briefly in the question, that Cafe Hollywood shouldn't take the responsibility for any of these attacks that happen off premises. And I believe when you were discussing the security force, you mentioned part of the reason was to make the patrons feel safe, to add to the safety of the neighborhood. So I'm just wondering where, the responsibility and the ability to help the neighborhood starts and ends, whether it's just at the establishment and making sure that it's safe around that area, or if Cafe Hollywood and Mr. Bruce feels any responsibility about anything that may have started at his establishment.
Well, on Colin's behalf, I'm sure that he takes it to heart when anybody gets hurt in his general area. I think we're people. I think nobody wants to see bad things happen to anybody. I mean, if there was a way that he could work in conjunction with the Albany Police Department to ameliorate or stop any hurt outside of his doors, he would do it. I mean, no question about it. Certainly, I think that if there was a way to work with a partnership with the Albany Police Department, that would be something that we would propose, and certainly we would accept their help. I know in the past that there have been inquiries by my client into the Albany Police Department to help. And look, we acknowledge that the Albany Police Department isn't a special security force for Cafe Hollywood or any other particular region or district in our city. But we submit that when we have an entertainment district, such as what Lark Street is, where you have perhaps 5 or 6 nighttime establishments that are really more bars than restaurants, there's a lot more or a greater increase in likelihood of events transpiring there in that particular quarter, as opposed to an area where you don't have people coming out and hanging out at nighttime. And that's why my client, I'm sure, would propose and extend his help to work in conjunction with the city, with this establishment, to prevent anything from happening outside.
Are you able to speak to that partnership anymore? I mean, would it be identifying issues in the neighborhood? Would it be helping to track issues that may have started in Cafe Hollywood?
Absolutely.
Okay. And I had saw an article where it looked like your client had reached out to the Albany Police Department for additional security or help leading up to the chief's emergency order to shut down. Can you speak at all as to maybe the thought process of that, or why a bar with such a large security force, a professional security force, would need the extra help from the police department?
Certainly. I respectfully submit those issues are related to things that happen outside of the bar. Albany Police Department shows up and tells you to move your car, you move your car. Some private security guy comes and knocks on your window and says, move your car, you say, yeah, right. I think the level of when somebody is asked to do something by a police officer, I think it's much more persuasive for that person to comply with the police officer's directive than that with a security officer who may be standing on the street. You understand what I'm saying? So if you're being a little too loud, if you're double parking your car or parking your cars on the wrong side of the street when it's alternate side of the street parking and they're taking up all these spots that shouldn't be taken up, if there's a fight, the level of responsibility to a police officer, I submit, as a society in general, is higher than that for private security. Especially when you're out in public area.
Given that, have there been any thought previously, I know you said you didn't think that staff or Mr. Roos had called the Albany Police Department when any of these incidents were happening in the establishment. Do you know, was there any thought, given the, as you said, Albany Police Department's higher standard, to call them instead of just going to the private security force?
I don't know if I understand your question.
You said that, the police department, by virtue, holds a higher standard or garners more respect from folks. So was there any consideration to calling them when there are these instances in the bar for the help as opposed to going to the higher security force?
I think that when the things happened inside the bar, they were dealt with by the private security. People were either ejected from the premises or whatever transgression that was occurring was minimized. Once things got outside, I think that if there were an incident that was happening, such as the November 2019 incident, I think the Albany Police Department were called and they were contacted, certainly. Such as the machete incident that happened in June. They were called, but it's almost reactionary at that point, instead of being something that's done before.
Yeah, thank you.
I had a question, Counsel. It was something that you said while you were responding to Mr. Klein. So you described the Lark Street corridor as an entertainment district and said that it had some characteristics that made it more likely for things to occur there. So my first question for you is, we're a zoning board, so we look at zones. Is there anything that you're aware of in the zoning code or anywhere else in the city code that would have labeled the Lark Street corridor an entertainment district?
Other than the amount of establishments that are catered to a nighttime audience, probably not. I mean, we could count, there was, and the restaurants, there's on Madison 1, 2, 3 bars and restaurants, right? There's Lionheart, Dark Tavern, there's the Japanese spot. You go around the corner, you have Justin's, or it's New Incarnation now. You go down a little further, you have Cafe Hollywood. Across the street, there's a pizzeria, a brick upper pizzeria that's open that serves alcohol. I mean, there's 5 or 6 bars. You go down the corner of State and Lark, there's a cafe, I forget the name of it, what number it is, 2 and 2 or something like that. There's a lot of places that people can go and drink and hang out. Even we're wrapping around to Washington Avenue, where the triangle is and Central Avenue begins. There's other establishments that are along that way that bring people in at nighttime. Different than, let's say, I'm trying to think of another area in the city. Let's say State Street between Pearl and Eagle Street.
So even though the Lark Street district is zoned as a mixed-use neighborhood center, which is nothing like the entertainment district, which I don't think we define in the zoning code, is it your opinion that having a number of restaurants and a number of bars in a neighborhood outweighs the residential character of the neighborhood? As Mr. Conti pointed out, it's a very densely inhabited residential neighborhood. So does having a few amenities in the neighborhood outweigh the residential character such that the people that live there should understand that there are going to be incidents?
To a certain degree, yes. I mean, look, if somebody's coming out of town, I want to go out with somebody, my friends out of town, I want to go out. People are going to flock. People are going to come to places where you can hang out. You can have dinner. You can have a drink. You can go for an after drink. You can go over here or over there. I think that the people who live in that neighborhood expect the influx of people. I think they like it. They live there for a reason. They want the same amenities that perhaps our out-of-town guests come to visit, but they want them to be able to walk, so they don't have to have that one drink or two, or they want the amenities of the park, or just the general walking neighborhood. So yeah, I think you live in a city a little tired. I think you have to deal with some things that you might not have to deal with if you live up in Half Moon on a half acre or an acre of land, and your next neighbor is very far down. Yeah.
Okay, thank you. Are there any other questions from the board?
I have one more question.
One more for you, council.
Only one?
Only one. I believe, correct me if I'm wrong, last time we heard from a number of the neighborhood associations who expressed concern about the activity at Cafe Hollywood. Have you or Mr. Roos reached out to the neighborhood associations or or any of those groups to discuss their concerns or anything to clear anything up?
Well, what we have done is we've engaged in negotiations with the city, and we had a panel of different participants, and we met with the city, we met with the chief, we met with individual police officers, we met with Mr. Conti. Everybody was there on one of these Zoom meetings. So yes, we didn't necessarily speak to the neighborhood association itself, but we went right to the top into the city and said, listen, what are you guys here? How can we make this better? And we are currently engaged in negotiations with the city to try to address these issues that we're discussing here this evening. Because ultimately, my client wants to open, as you've acknowledged. He's a business person. He's been a business person for a long time in the city of Albany. He wants to continue his business. This is his livelihood, but not just his livelihood, that of all of his employees, the security people. And our goal is to have a joint partnership with the city, and not to be a war. This is a war that no one wins. The city loses, we lose, and we want the opportunity to be able to be open and to have a joint partnership with all the players, including the neighborhood associations. I didn't think they'd include that, and perhaps that would be a great suggestion that we take their input as well.
Thank you.
Thank you, Councilor. If you can stick around, we're going to ask for any public opinion, either from people on Zoom or in the audience that want to offer public opinion.
Excuse me, can I just make a point of for clarification? And Mr. Hannigan, I just want to say I sincerely appreciate your position and respect your zealous representation of your client. Just for purposes of the public record, the 911 calls for other establishments in the Lark Street corridor that you requested on August 10th. That was provided to you by email on August 12th by my colleague Robert D. It was also entered into the BZA online public record on or around August 25th. And this is an important clarification because the board can't consider that information unless it was entered into the public record. It was referenced by Mr. Conti, but it has been in the public record for the last 2 weeks, and as I mentioned, was sent to you by email about 4 weeks ago.
Thank you. I was speaking more to my FOIL request about all of the other calls for service and things like that, just not the 911 ones.
Oh, that was provided, but okay.
Thank you.
Mr. Chairman, I'm gonna step out for 30 seconds to make sure that it goes with the last one.
Okay. And Luis, do we have anyone waiting online who wants to offer public opinion?
So, not online. I put a request out for individuals to notify if they're looking to provide comment for this. I didn't see anybody specifically indicate on their registration that they were looking to provide comments. So I'll just throw another poll out just in case anybody joins in later. If you are looking to provide public opinion on this, just raise your hand and I will be able to unmute you to provide your public opinion.
Thank you. Do we have anyone signed up in our live audience?
We have one individual signed up in our live audience, for each show 30.
Okay. And if you'd like to come up and provide public opinion for us, please identify yourself by name and address. And you get 3 minutes.
3 minutes? Okay. Can I get 1 minute warning?
Yes.
So my name is Alicia Purdy, 173 North Main Ave in Albany. So I'm here in 2 capacities. First of all, I'm running for mayor in the city of Albany. And I'm also here as a civilian. But I do want to say, just to your point, Mr. Chair, that I actually have never driven really drinking my whole life. So I'll put that up there. I'm not one of those people. Early on when this occurred, I too foiled a bunch of requests because I was very interested, and I'm running for mayor, so I was really interested to see what were the calls and the comparisons. And so the only one that came back for me, and it wasn't, I didn't even do it, I was too afraid to do it under my own name because I thought they'll never give it to me. So I had a bunch of other people do it, and the only thing that came back was Bombers on Clark Street. Bombers had comparable calls. I think it was 1 or 2 fewer. Of a slightly different nature. And one of the things that really stood out to me about the calls that I saw at Cafe Hollywood was that they had to do with things that were around Cafe Hollywood. They had to do with people pointing to Cafe Hollywood. Hey, it happened when I was near Cafe Hollywood. That struck me because what I don't want to do in Albany is hold somebody accountable for something that other people aren't being held accountable for. And I can appreciate that Cafe Hollywood stocked their establishment with greater security. I think we should all do that. I think there should be more, I think every bar should invest in their security, especially when you're in a residential area, as you mentioned. They had mentioned before, I did notice that they mentioned that APD had been called for help. And they had, when I spoke with them, I spoke to both sides. And I heard that, the city should not provide personal security detail. I agree with that. However, I do believe the city of Albany has a personal responsibility here to keep the streets clean, to keep the streets safe, and that, where outside of an establishment culpability begins and ends sounds like it's ambiguous and should be clarified down the road. The fact is Albany Police Department is underfunded and there aren't enough people anyway to show up. But I think it would be great in a bar or restaurant district or entertainment area, mixed use residential, there should be increased police presence on a Friday and a Saturday night. So I want to put that out there. But really what I think this is Cafe Hollywood paying a heavy price for a failure to effectively address crime in Albany. And that has to do with not only the mayor and the police chief, but also other people that are staying silent on this issue. What I want to say is whatever, cabaret license, use expanding, whatever those issues are, they could have been solved and should have been solved before this in another way. Thank you. My great concern, really, I will say this, is word on the street in Albany is that this was a racial move. And I'm just going to say what nobody else has been willing to say. I have talked to people across the city of Albany. They are very upset because they think this sends a message to people of color and that this was about. So I'm speaking not even of my own opinion here, but I'm letting you know that word on the street in the city of Albany is, it is a crime to be a person of color and go out and have a nice evening. Because gathering together in too many things makes too much noise in a rich white district. As a mayoral candidate, that is stunning to me. Tell me 1 minute. Is that? I
think that's your 30 seconds.
Okay. That's very stunning to me, and we can all see that crime has gone up. It has not gone down, regardless of whether it's at Cafe Hollywood or not. This is a Hail Mary for crime. And so what I'm saying is you have the power to do something about this. It's an abuse of power to shut down Cafe Hollywood and make them the whipping boy for this situation. Not the only nuisance business, and we all know that. So I just want to express that to you. I'm not on one side or the other. I'm on the side of Albany. But you do have the power to help a small business and to send a message to people of Albany. And I hope that you'll do that. So thank you.
Thank you. Do we have other folks in the audience who wish to stand up and speak for or against the proposition in front of the board? Okay, seeing none. While we would have liked to have come to a final decision on the first phase, which is whether or not to find a public nuisance tonight, the fact that the Cafe Hollywood's FOIL request has not been answered yet leads the board to believe that we should hold over until the next meeting in 2 weeks. And hopefully, Mr. Ross and his council will have the FOIL response by then, and we'll be able to address that in a survey level in front of the board at the 4th Wednesday of the month.
Also, Mr. Chairman, I appreciate that the city police department provided those very detailed records. I can pull kernels out there, but they're really hard to put side by side because to you guys, they're technical documents about who responded and when and who arrived on the scene and what time, and they're full of numbers that reference certain codes, but it's really hard to take a number where we heard Brad Glass talk about, the calls to Price Chopper, 331 calls to Price Chopper, which may not be on the same level. It may be a shoplifting call or a check a subject or an alarm or a door versus, I think what we're talking about here tonight are a proliferation of violent incidents. So if there's anything that the department can do to supplement that record to be able to help, because I'm getting astigmatism reading the records, It's really hard for me as a non-technical person in law enforcement to understand those records if they're not summarized, so.
Thank you, Martin. And if Corporation Counsel could assist and talk with APD for us on that issue, that would be very helpful.
Absolutely, thank you. And I don't know for the complainants, Mr. Conti or if Mr. Glass is still on Zoom, if they want to respond to Mr. Hannigan's kind of question or request for entering into negotiation or partnering with the city in that capacity.
Was there Mr. General or if I want to, I mean, there are some discussions going on, we'll see what happens. With regard to, the incidents that occur.
Mr. Conti, can I be speaking to the mic?
Yeah, sorry. With regard to the incidents, I mean, what you heard was they originated in the establishment, security separates the parties, one is let out at some point later than the other, and then it picks up outside. But there's a connection between the incident that occurred and what happened outside. And officers from the APD are here tonight, and they can address those questions, particularly with regard to the two issues, the machete and the homicide, and what their investigation shows as far as the connection.
And just to answer the question that wanted to put to you, Mr. Calvin, she wanted to know if you wanted to speak to the fact of whether or not the city and or you and the establishment were in conversations, whether or not settlement, but at least discussing the issue.
Yes, we are in discussion. There's some proposals been traded back and forth. There's no conclusions at this point.
Thank you.
We'll see what the outcome is.
Okay. In that case, then we'll move on to the next case and we will pick this up again at our next meeting in 2 weeks. Thank you for your presentation.
Can I ask the board just for a clarification on whether the next meeting will be a public hearing continuation or will it be a public meeting?
It'll still be a public hearing.
Let the record reflect my sunroof was open. So, I'm glad I went out there. Yeah, not too bad.
Do you want me to fix that microphone?
It depends how long it would take you to fix it.
We're going to take a brief break and then we'll pick up with 161 Washington Avenue Extension. Greg Fischel will be presenting.
I don't know what that means.
I've gone through actually every single record. So, but like because I have here we have
Do we get these? Sorry.
Okay.
That's great. This is helpful. Yes. Because I can't,
We can share.
For sure. What time be?
What time will be done tonight?
No, reconvene. It's 7:31.
Oh, 5 minutes.
Okay.
this is what I was, Richard, this is what I was talking about, these records, I'm talking,
Yes. It makes a lot of sense to, but
it's like, get an Excel spreadsheet and show me
I
number
would like
lines.
a chart like this percentage is
The chart is just easier. I like police procedural dramas, the more procedural the better, but this is too procedural.
well, it's procedural in real life.
Oh, yeah. Like they just cut to it, like they're chasing the bad guys. He's only working on one case?
Yeah, no, good point.
Were your windows open?
My sunroof was open. So I got to it though. Not too bad.
I could have been bad.
Yeah, I'm glad I made that effort.
I had a friend who had like a convertible that got ruined by a rainstorm.
That's true.
I don't understand, like, I can push the keys off and open my windows. Why can't they close when it's raining? Right?
I never had a car that could do that.
My car can follow, it's a Honda, it's not fancy, it can follow another car, the cruise control adapt and whatever, it'll brake for you.
My car's older than that.
Can't close the windows when it rains, like the thing that you absolutely think is essential. Maybe it's a safety thing.
I think what you're asking for is the epitome of the nanny state.
Just save me from having a soaked car at home.
I like the idea of the other one out there.
There's a nice break.
Yeah. You didn't miss anything. Yeah, disappointed by that.
Yeah, that was, well, not a lot, that was free. Hopefully the next, I mean, I also thought the press conference was inappropriate. Yeah, what this is.
It's also the left to the business and the, you managed to offend both parties. Like people live in the neighborhood.
I was like, that's my neighborhood.
Yeah, that's your neighbor, that's your neighbor.
Like, I'm on the other end, but like, it's mine.
Yeah, no, it's,
You know, they also got a laugh out of getting up there and opening, just for the record, I've never had a drink while driving, like,
I mean, to be fair, I haven't either.
I know,
So I'm
no one
like,
has.
I'd like to go on record as a teacher.
This makes me think of Bill Clinton, where he said he never inhaled. He was like, either you're a liar or a weenie.
Guess I'm a weenie. I lived in Mississippi where you couldn't drive without weenie container. It's like,
Yeah.
not that.
yeah, Louisiana, you're past, you can go through a drive-through liquor store.
I mean, at first I didn't own a car until I moved here, so.
For the record,
That's
That's what I hear, right? I heard it on the street.
My friend's dad was a DARE officer, and he swore to me one time, we were driving up to Montreal, and we had soda in the car. And he was like, you can't open any containers in my car. It's an open container law, my dad's a police officer. Your dad must be so disappointed in you. That doesn't apply to Pepsi.
That's fine.
Well, that's funny.
Mississippi, they're good. No, each one?
You almost ready again?
Yeah.
Okay.
I only learned what a reading was like 2 years ago. 5 years ago.
So Dre didn't educate you?
He doesn't
I've seen you, Dre.
Yeah, I used to work for a law firm and we had a trial in Louisiana where they have drive-through daiquiri places, and our attorneys loved it because court was closed on Friday, so every Thursday they'd be like, all right, we're gonna go get drive-through daiquiris and bring them back to local council office.
I can't think of a more just dangerous average devil. I guess it doesn't smell as fast.
Well, they take the straw,
Yeah.
so.
Wendy's shakes are the best. Pick them up real fast.
Because they're solid as a rock.
Yeah, they're not going to dump out.
Well, it's like Dairy Queen has the whole, once they make your blizzard, they tip it upside down to show you how thick it is.
Yeah.
I didn't know Dairy Queen still existed.
There's one.
Western New York.
Really?
There's one out in, what's Karosky direction, I don't go out there.
Well, I think it's up, Central.
I think it is on Central.
Yeah.
I know because last year on my birthday, I went to Dairy Queen and sat in my car and ate peanut butter parfait.
Well, it was like, if other people were gonna be
You
coming
know what's
in,
really funny on Google? They
but
have
I
like,
feel like no
it's
one's
like,
really
oh,
coming
eat whatever,
in.
it says great place to eat in your car by yourself. Like, and I'm like sitting there like, oh.
Did they have your picture?
That's really kind of
No, they're like, here's a sad girl
Oh,
eating
that's funny.
Dairy Queen by
I can
herself.
confirm that that's
I was like, it's great, I agree with that.
Workshop. Okay, we'll get started in a moment. I think our council is still out, and there she is. She was in the hallway. Okay, Luis, you want to bring up 161?
Thank you. So the public workshop agenda, the first question, or the only item on the public workshop agenda is 161 Washington Avenue Extension. So I'll just be going over the request here. This is represented by Greg Fishel from Allied Siding Company. This is for a sign, for square footage for a sign. The proposal is a 100 square foot wall sign in a mixed use community highway zoning district where 32 square feet is the maximum signage allowed. This is just an overview of the premises, 161 Washington Avenue, otherwise known as Crossgate Commons. The highlighted red portion is the area where the individual is renting. From my understanding, I believe it only applies to the frontage facing away from Washington Avenue extension next to the Planet Fitness, and that the entrance does not extend all the way to the other side. And that's of note because that means that they only have one frontage and not two, which would mean that they would only be allowed the 32 square feet as opposed to 64 if they had two frontages. So in this case, they would be requesting 100, where 32 is allowed, not 64, as it would maybe appear on this site plan.
So north side, throughway side?
Not the throughway side, but the spacing, or I'm sorry, not the Washington Avenue extension, but the throughway side, yes. So the sign ordinance in question, on-premises signs that require a sign permit and the size, once again, 32 square feet is maximum allowed, and they are proposing 100 square feet. Now, there is a bonus applied in a mixed-use community highway, but this would not apply since they don't have the linear feet of frontage to qualify. So the criteria in making a determination regarding a request for an area variance, the BZA shall take into consideration the benefit to the applicant if the variance is granted, as weighed against the detriment to the health, safety, and welfare of the neighborhood or community. In making such a determination, the BZA shall consider 5 points here. We'll be going through one by one. The first, whether an undesirable change will be produced in the character of the neighborhood or determined to nearby properties will be created by the granting of the area variance. In this case here, the applicant indicated that, well, first the applicant did not state whether the variance is actually consistent with the character of the surrounding properties, but the applicant did state that the variance would not change the character of the neighborhood because the proposed sign would be the smallest sign in the immediate plaza area per square foot. The applicant states that the average signage is 529 square feet when considering 4 signs, and they indicated the signs that would be on the same frontage facing the thruway, which would be Michael's, Planet Fitness, Ninja Lab, and At Home, to determine that square footage or average. Second one, whether the benefits sought by, or if you have any questions at this point or comments, I can take them, I can continue forward.
Okay, might as well jump in. Did any of those other signs get variances, or were they all put in under the old code?
They were all either put in under the old code or applied for variances since 2017. I think those 4 specifically were not under the after the 2017 ordinance change, so they were under the old code.
Ninja Lab is new, I think.
They don't have a sign permit or,
Okay.
yeah.
Yeah, I have a question too, Louise. We saw a case, I think it was 3 years ago, Mark?
Skechers, right? That was
Yeah.
fun.
And we
My
saw-
hot tub was in the front.
The difference in those is that I believe the Skechers one had a corner spot, so they had 2 frontages that way. Whereas opposed to this one is basically kind of landlocked, you would say, between 2 other suites, and they don't have access to the other side, which would mean they only have 1 frontage, so they only get the 32 square feet. Skechers was able to use the off-premises sign program and take advantage of that, and they were able to get their sign without having to use the variance.
Thanks.
We're gonna jump on next. You've opened the floodgates. Have they discussed in their application their thought about potentially using that to locate a sign on another end of the building for directional purposes?
I can reach out to the applicant on that.
Okay. It would seem if a larger sign is needed for wayfinding, it might be possible to locate another sign if that's a provision the city allows on the side of the building. And the other question is, there's a monument sign out in front of that plaza. Are they going to have a sign on the monument sign as well?
Yes, I would assume they have the ability to, since that's what the site is, but it wasn't made clear in the application, or the applicant cited that though.
Sorry, yeah.
The second category is whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than the area variance. And the applicant provided here a chart used to determine the letter height. The chart's a little hard to read, but essentially the part that's relevant here would be the one here that says 300 feet, which is what the applicant estimates is the distance to the major road, which would indicate that letter height is recommended at 30 inches. The applicant indicates that they have requested 28 inches for their letter height, and uses this as a reference as to why they chose that height and therefore the variance. The applicant cites the standard. It is of note that the source is focused on California for their source or standard or applicability of these standards. So that just might need to be something that the board would want to consider as well.
Luis, does the applicant have any sources from New York State that they might be able to put on the record?
The applicant identified their benefits sought for the variance as twofold, one being greater business recognition and the other being location awareness for potential customers. The applicant, as previously mentioned, indicated the letter height was calculated using a letter visibility chart, which resulted in a 30-inch letter height recommendation. The applicant states that if signage were smaller, visibility would be hard for customers to locate among larger signs in the plaza. Of note, for staff note here, the applicant does not mention alternative sign options such as counter letter signage that would allow the same letter height while also reducing the variance being requested.
How many storefronts are back there? 4?
I believe 4, yes. On that one. If you go across the street, there are more. I think that's a Walmart. But on that specific stretch divided by the Crosby Commons is 4. The third category is whether the requested area variance is substantial. The applicant states that the requested variance is not a substantial departure from the USDO, but makes a contextual argument that the sign is smaller than the surrounding signs, and although it is a 300% deviation, it's only 19% of the average mean of the square footage for signage in the plaza. Staff note here is that the requested variance is a significant departure from the prevailing regulation. For whether the proposed variance will have an adverse effect or impact on the physical or environmental condition in the neighborhood or district. And the applicant indicated that there was no impact. However, the applicant did not indicate how that was going, or how there would be no impact. So the statement is conclusive.
So just as a curiosity, is the sign lit? Is it internally lit? Is it externally lit? Are we, those factors we'd want as part of the application. Certainly from an element of light pollution, we want to be able to address that question.
The last one is whether the alleged difficulty was self-created, which consideration shall be relevant to the decision of the BZA, but shall not necessarily preclude the granting of the area variance. And the applicant states that the need for the variance is self-created.
Thanks, Luis. Are there anything that the board wishes Luis to reach out to the applicant and seek for us before we do this next week or 2 weeks?
You know what business it is?
The business would be for myhottub.com.
Oh, so were they in the? Did this change from the front?
The-
I'm getting deja vu all over again.
Yeah, the applicant was originally here, I believe, in March or April of this
Okay.
year. The applicant did not have a robust application. The applicant was asked to provide additional documentation, and subsequently they withdrew their application and said they would be back at a later date with the supporting documentation. The applicant then, at that point, I think, gained a representation of Allied Sign, and they are now submitting for the variance.
Okay. That's where I get the memory from.
Yeah.
Thanks.
Okay, thank you, Luis. I don't think we need anything else from that. In that case, let's move on to the public meeting agenda, Luis.
Okay.
And our first case is 23 Hackett Boulevard. Were there any wishes of the board?
like to make a motion to approve the requested variances for the addition
Thank you. Do I have a second for that motion?
Second.
Thank you. All those in favor of granting the variance for the school year, please say aye.
Aye.
Any opposed? Motion carries. Thank you. Our next case is 23 Hackett Boulevard, and we also have 65 Frank Street, which are both being put forward by, I'm sorry, 65 Frank Street and 42 South Dove Street, which are being put forward by the same applicant. The applicant is here. If you want to make any additional argument, or you're welcome to if you would.
My name is Amy Mason. I'm from Azo Rich Consulting. So after the last meeting, we have made some adjustments to our variance requests. So on 65 Crank, we did reduce the amount of variances from 7 to 6. And then we also did reduce the size of the monument design.
Thank you. And what about 42 South Dove?
Sorry, just hold on my paperwork here. With 42 South Dove, again, we also reduced the monument sign to match the existing size that is currently in place.
So for 42, it's an 8-foot tall monument sign.
We had originally proposed an 8-foot monument sign, and we reduced it to a 7-foot tall monument sign.
Okay.
So now the top of the star is at the same level as the top of the current existing sign.
And for, forgive me, for 65 Crank Street, you made a modification to the size of the monument sign. Could you just note what that modification is?
I can. So we reduced the size by 1/4 on that sign. So it went, let me just get to that slide. At the original meeting, it was 8 feet. And
8 feet tall?
yes, and now we're down to 7 feet.
7, okay. And is the sign now 43 square feet? I just want to make sure we're going to make a motion that we have the correct dimensions for the board, so there's no confusion between the actions and the application.
I completely understand.
Use your microphone more.
Oh, I have a microphone. I just want to make sure that if we're going to make a motion, that we have the accurate numbers, so there's no discrepancy between your application and the action the board takes.
Yeah, so we have reduced that size to 30.5 square feet. The original request was 43.
Okay. So I want to clarify just the two things. I want to make sure we don't have to, we don't have to convince anybody if there's a necessity to go back after an action is taken. So the height of the monument sign at 65 Crank Street is 7 feet, and the square footage of the monument sign at Crank Street is now 30.5 square feet?
Yes, sir.
Okay. And then for 42 South Dove, the monument sign is now 7 feet tall.
That is correct.
Okay. Thank you.
Are there any wishes of the board?
Mr. Chairman, I'd like to make a motion to approve the variance request for 65, let's do these separately. I'd like to make a motion to approve the variance request for 65 Crank Street, area variance 83, area variance 84, area variance 85, area variance 86, area variance 87, and area variance 88, with the notation that the monument sign will be 30.5 square feet in size.
Thank you. Do we have a second?
Second.
Second. Thank you. All those in favor of this motion, please vote aye.
Aye.
Aye. None opposed, motion carries. Do you have any further motions you wish to make, Mr.
I do, Mr. Chairman. I would like to make a motion for application property address 42 South Dove Street. I'd like to make a motion the board approve the area variance 89, 91, and 92 with notation that the monument sign is 7 feet tall.
Thank you. Do I have a second for that motion? Thank you. We have a second, and all those in favor?
Aye.
Aye. None opposed, both motions carry. Thank you.
Thank you.
Our last case that we'll consider tonight is 1415 Washington Avenue. Mr. Hershberg, do you want to present any more on that?
Thank you, Mr. Chairman. I'm Daniel Hirschberg. With me today is Evan Podog from Scenic Investments and Andrew Brick, the attorney for this project. We initially had this variance approved, but it was approved out of order because the secret determination was not made. And at the last meeting of the planning board, the secret determination has been made. So an egg deck was issued. So we're back in front of you. You may recall that this required that we had to start the building 10 feet from the front property line in an area where there was not very much area left. There was easements crossing it. It would have been infeasible to have honor that 10-foot front setback, and this board was nice enough to concur.
Thank you, Mr. Hirschberg. I remember a great deal of discussion about this earlier on historical easements and all that sort of stuff. Are there any wishes of the board on this project?
Mr. Chairman, I'd like to make a motion to approve the requested variance at 1415 Washington Avenue.
Thank you. Do we have a second for that?
I'll second.
Thank you. All those in favor, please vote aye.
Aye.
Aye. None opposed, motion carries.
Thank you very much. Thank you all.
Thank you.
Have a nice evening. On to the next game.
Sticking around.
Sorry.
Sorry, can I just point one other clarification for us? That Chair Berkeley mentioned at the beginning, so is the board on board to go remote hereafter? Yes, okay.
Is the board on board?
Choice.
And we can, I mean, the public meeting law has changed. We can do hybrid if you want to. I'm going to go remote myself.
Yeah. I think it's easier for staff to go remote, and I'm happy to do that.
And after the Typhoid Martin incident, that's rather,
So when we're remote, are you all here? I know you're usually here, are you, no, you're not, you're.
If we're remote, we're all gonna be remote.
Okay, so from anywhere. Okay, good.
So you don't have to give us your address for where you are.
yeah, no, it's been taken out of the law by the legislature.
So
Well,
I think your
yeah.
dog will be joining future
Yeah, he
meetings,
will.
yes.
So, thank you all, of course, as always, and I'd like to close the record, Louise, and thank you all for your hard work.
All right.
Goodbye.
No, that's thunder.
I thought someone said.
Hey, bye.
That was mine.
Oh, you said bye. I think you said